The unfortunate reality, so many people find white collar advice, not just after they're involved in a government investigation, but after the investigation has begun, they continue to make bad choices. I had a bad proffer. What does that mean? I don't agree with my plea agreement. Can I have a do-over? Do-overs don't exist. So we want all of you traversing the system to make really good decisions the second you become immersed in a government investigation. And to help all of you do that, I'm really proud to recognize and bring on my friend Andrew Bernstein to our show. Andrew, welcome. Thank you for sharing your expertise with us. Could you give us a moment about your background? And then I'd love to jump into some questions that I know people will really find of value.
Sure, certainly. First off, thanks for having me. It's a pleasure. Andrew Bernstein, I'm a partner at Fox Rothschild, white collar criminal defense and government investigations. I am proud to say I've had a sort of unique road to getting to white collar criminal defense. I was originally a New York City public defender for the first 4 years of my career. Best professional 4 professional years of my career, worst 4 professional years of my career. It was not white collar, murders, rapes, robbery, some white collarish types of crimes, but not sort of clientele. But that was great experience, a lot of trial experience for me. It's where I, got my identity really as a trial lawyer. From there, I went into private practice, my own small firm. And by happen chance, my very first client on a non-white collar matter was a well-known short seller. And that sort of changed the trajectory of my career. And since 2016, really all I've done is white collar criminal defense. From there, I went to a boutique securities firm, spent a few years there, went to a Am Law 200 firm, and just recently I joined Fox, which is an Am Law 100 firm. Those are all, fancy words to say the size of the firm. What I love to do is white collar defense, defending individuals, in entities. And Fox has given me a platform to do that on the largest stage. But that's a little bit about me, and I'm happy to discuss. I hope it's obvious my love for defending individuals and corporations.
I want to jump into some questions that we receive, and frankly, some concerns. There are people, as crazy as it sounds, who will go to a proffer unprepared, just like some people go to a probation interview unprepared. It's an interview. They're going to ask you questions, speak openly and honestly. Hard to do that if the person doesn't even understand how they became immersed in a government investigation. So I'd like you to touch on what exactly is a proffer, and how can a proffer go bad for people
Sure.
watching?
So a proffer is an opportunity to meet and speak with the government. So some people call it a queen for a day. I refer to it as a proffer. Proffer is a meeting with the government, and it's covered by a proffer agreement. We can get into why some people don't want to sign the agreements, but that's a whole different story. But the proffer agreement essentially says everything you say to the government is confidential and won't be used against you to prosecute you. However, what you say can be used by the government for them to continue investigating. Usually the example the government says is if you robbed a bank and you say the money's buried under a tree, they can't use that statement against you, but they can certainly go to the tree and dig up the money. I like the simplistic example they give. I don't always like the examples they give, but that one's fine. So at a proffer agreement, depending on which stage you are in the matter. So if we're talking there's been no indictment, no arrest, the proffer is potentially your opportunity to explain to the government your side of the story, if you will, or give some background to your actions, what was going on in your head. The hope of a proffer at that stage is that you're not charged, or that if you're going to be charged, you're going to be charged with something less than what the government's thinking. Or perhaps it's an opportunity for you in the government to think about cooperation or some other way to resolve the matter. So it's a general term used in many scenarios, but really it's a meeting with the government. You've got to be honest, and if you're not, you can be charged with a crime for lying to the government.
When we speak about going bad, is that perhaps not just lying, but perhaps not clarifying what they already know? I mean, is it likely that the majority of what they ask you, they already know, yet some defendants may not clarify, sort of feign ignorance, be afraid to speak, not even know how to respond? How can a proffer go that, besides the obvious of lying? Is it not seizing opportunities that could advance your agenda? Help
Yep.
us understand that, because some people are afraid to proffer. And frankly, I know some lawyers tell their clients, I don't want you to proffer. And another lawyer may say, I want you to proffer. Help us understand when they go bad.
Sure. The easy answer is a proffer can go bad in a million ways. At the end of the day, I think it's the focus on understanding, can my client go in? Should my client go in? So if you're an individual considering this with your lawyer, first thing is you've got to be honest. If you can't be honest, you can't go in. And to your point earlier about what that means, it doesn't just mean that you're telling the truth when asked a question. It means you're not minimizing. If the government asks you who was in the office that day, or rather, were you in the office that day? Yes. Did you meet with so-and-so? Yes. They also expect you to say, and not only was Andrew and Justin was there, but these 6 other people. Now, if you can only remember 3 or 4, or you say a couple people are there and you're being honest, fine. But material misrepresentations, right? So you are leaving something out on purpose and it's material. That to the government is just as bad as lying. And a lot of clients have a hard time with that. I was asked, what did I have for lunch today? Hamburgers, an honest answer. Well, you had fries, you had a drink. And those are not immaterial things to what you had for lunch. So the government, as you said, the government knows a lot. They don't know everything all the time, but they know a lot. As I let clients know, I think usually the first portion of a proffer, whether that be the first 20 minutes, first hour, whatever, they're asking you all the questions that they already know the answers to. They're trying to judge your credibility. And, if you're particularly early on, right, you haven't been indicted, there's no arrest yet, the government's also asking themselves, is this person credible as a potential witness? Is this person credible such that if we decide not to prosecute them, we can go back to our supervisors and say, we looked this guy in the eye and he's credible. So it's not just, are you being truthful, but it's getting a sense of, could we work with this person? Do we want to give this person the benefit of the doubt? So all of that comes from this notion of, we've done our homework, we know a lot, we're asking you questions, and now we want to see how you answer. Inevitably, at some point, they are getting to the process or the point of the conversation where they're asking you something that they don't know, right? And so after hundreds of questions that seem exactly the same as the questions where they don't know the answer, you're in this area where you don't know if they know the answer or not. But you've got to tell the truth, and you've got to tell the entire truth. If you can't do that, and there are reasons why, right? You are guilty of or culpable of more than maybe the government is aware of, and you don't want to go in and tell them that. Maybe the client is a very difficult person, or perhaps they're just an unusual individual who's actually telling the truth, but for whatever reason, they may come across a certain way. Whatever. If you can't be honest, fully honest, then you can't go in. I think there's the conversation of should you go in. But once you have that conversation of should you go in, you've got to be honest, and you've got to tell your story in a way that's credible and believable.
Well, let's talk about honesty. And I discussed this with our colleague, Ron Chapman, who's in Michigan, I believe. And I asked him about the value or the need to work openly and honestly with your lawyer, right? You can't speak openly with the government and answer honestly if you haven't worked openly with your lawyer. Can you discuss how valuable, not even how it is essential, someone who hires you to tell you everything, the value of that? And how do you help people charged with a white collar crime who never imagined in a million years they would get involved in this system, probably don't know anyone going through this system? They're in shock, they're in crisis. Discuss the value of working openly with them and how you get them to do it.
Sure. Look, the value of it is priceless, because if client is not being open and honest with you, you may not be able to give them the best advice. And a lot of times clients feel, well, you don't need to know this because the government doesn't know it, you don't know it. But if we don't know where the bodies are buried, so to speak, we might step in the wrong place. We might lead the government to the wrong place. We don't want to do that. I cannot give you advice unless you've been fully open and honest with me. I want to flip this to the other side for a second. As you talked about earlier, I think before we were on camera, it's difficult, the client is being difficult, or they don't want to tell you for whatever reason. I put the onus on the lawyer. You've got to build a relationship with your client. You've got to build a rapport. And once they see you as, a credible source of knowledge, their defender, their advocate, their counsel, they have to understand that you're telling them the accurate truth and that they've got to trust you. You build that relationship and you can explain, look, throw your common sense out the window, or don't look at it the way you look at things in your sector. This is what the government does. This is how they operate. Yes, telling them this very scary, inculpatory fact is going to be good for you. A lot of people hear that and they can't wrap their arms around it. So I think number one, it's building the relationship with the client, getting them to understand why you're doing this. But yes, if you're not being honest with your lawyer, lawyer cannot help you to the maximum extent. In fact, it can hurt.
But before I go to the next question, Andrew mentioned he was a public defender. My lawyer, Bob Corbin, who I think is retired now in Los Angeles, was a federal public defender in New York for a long time. And when I hired him after I had a bad relationship previously, and then I went to Bob and Joel Athey, Bob said, I was a federal public defender in New York. Whatever you're going to tell me, I have heard a million times worse. I can assure you, whatever you're going to say, I've heard. To help you, you've got to tell me the truth. In fact, the more bad things you say, similar to what you just said, the more it can help you. And when I had a meeting with the government, it was actually the prosecutor is now a defense attorney. I shared something with him and he was surprised that I said it, and it made me look worse. But by saying it, it actually made me look better. I had shared something that they didn't know, and they saw that I was credible. Before we go on, well, actually, I want to transition to the next question now. Frequently, we'll hear, nothing I do matters. I'm not going to mitigate. The judge's mind is already made up. Do you believe that some judges sit down at the bench and the mind is already made up at a sentencing hearing? Help us understand that, because there are some people who call us after they got sentenced and say, nothing I would have done mattered anyway. The judge's mind would made up. Walk us through that.
So I think, unfortunately, sometimes that's true. But I am of the mindset that you can always, it's situational. It's dependent on the situation, but you can always change a judge's mind outside of a few small scenarios, right? So sometimes you have a judge who says, that maybe it was a trial case or something, or there was a hearing or whatever. There's a Fatico hearing. They have, lived with this case different than the rest of their cases, right? We're not talking about status conference, plea hearing, and now it's sentencing. I don't know the client's, wife's name. I don't know this or that, right? I had a hearing recently, and I said to the client, this will either be a 5-minute sentencing hearing or a 3-hour sentencing hearing. This judge, very experienced judge, very confident, basically said, look, Mr. So-and-so, you have a great lawyer. The government has put a lot of effort into this. I'm happy to hear from all sides. However, at this moment, my mind is that I'm going to give X sentence, which was the bottom of the guideline, on a mandatory minimum, bottom of the guideline. I looked at my client, and we had nothing to say other than, Judge, will be some housekeeping requests after you make your pronouncement. That's a time where we're happy that that's happened. To the fear of what people are speaking of is the judge has made up their mind, they're not listening. I don't believe that. I believe even the judge that is not paying attention, so it looks like, right, or is scribbling or is not taking notes, if you say something that is not, maybe they haven't thought about, or said something in a different way, or said something that you think motivates them to look at this person more as an individual, or this case slightly different, I do think you can change client's mind. I know it sounds like a sales pitch, but the truth is, mitigation team, your lawyer, your advocate, there's always something I think we can do to paint you and your case differently. So you'd be surprised. I've had comments from judges, tough sentencing judges, who said, I was walking in here today and I was going to give you X, Y, and Z. However, I heard this today and I'm going to give you a better sentence. Now, on the flip side of that, right, and I'm not trying to put the onus on the client, but there are times where Judges have said, and look, we've tried everything we can to say to the client, just like a proffer or just like any other scenario, either don't speak or speak. And I think a client should always speak in sentencing, even if it's very little. I think clients should always speak. But if the client gets up and doesn't show real remorse or doesn't take real responsibility, then judges have, judges have said, look, I came in here today wanting to give you this, but you've clearly shown that you don't understand, you don't care for the victims, you have no remorse for your conduct. This is hubris, arrogance, and the judge gave a worse sentence. So it does work both ways, but yes, I think 99% of the time you can change a judge's mind. And what I would say to someone who's come to you or me and says, would it made a difference? You're contacting us now because you're unhappy with your sentence. Deep down inside, you feel that there's something else you could have done, right? You can get a bad sentence, but if you feel I've hired the right people, we've done all that we can do, we've painted me as the human being, we didn't make excuses, but we provided context. And yeah, that sentence, it seems like, is easier to serve than the one where we didn't do the best that we could.
I have one thought before our final question. If you buy into this belief the judge's mind is made up, the alternative is do as much as you can before the sentencing to influence him if his mind is made up, influencing the probation report, working with your lawyer to influence the recommendation the government may make, get involved in the sentencing memorandum the judge may read before sentencing. So if you believe that, do as much as you can before, if you even believe his decision is already made. My final question, and for all of you, Andrew is profiled in our legal directory, Top WCA, that features a few lawyers in every district. Last year, we sent out more than 400 referrals to lawyers across the country because we get so many calls from people who don't know how to hire a lawyer. They regret their lawyer. So we're proud to feature him. And I can assure you part of the reason we're featuring him is because he doesn't buy into this idea that it's too early to prepare. And that's how I'll close. We hear this a lot. I've just been indicted. My lawyer said it's too early to start mitigating. Sit back and relax and get off the internet. The prosecutor's working full time. The DOJ is issuing press releases. Your banks are firing you. Your wife may leave you. You're hiring lawyers. You're losing your careers. I mean, I only have 10 fingers, but I could go to 1,000 of the collateral consequences. Can you discuss the value of preparing every day to mitigate not just the sentence, but all of the collateral consequences that accompany a conviction or investigation?
Look, it's invaluable, and you can never start. You can start the moment that you're aware of an investigation, or you can start late. That's the way I look at it. So, when I meet a client for the very first time, I say to them, and look, every now and then you get a client who says, well, I don't like that mindset, but I try to explain to them and educate them why I have it. We're meeting for the very first time. There's a subpoena out to your employer. We're getting wind that you're a target. This is just something you've lived with for a couple of days. I am already preparing for two things, and we'll prepare for them until the very end of this matter. I'm preparing for a trial that we hope we don't have to have. And the reality is, in the federal system, it's more of a sentencing practice than a trial practice. I'm preparing for sentencing and for mitigation from day one. I say to my clients, I'm going to ask you things a certain way. We're going to talk about certain things. I want to assess, can you do a proffer? But I'm not just assessing, can you do a proffer? How are you going to do with the probation officer? How are you going to do at sentencing? How are you going to assist in mitigation? So I think you start the day you get a matter, focusing on trial and focusing on mitigation and sentencing. You covered on a couple topics there. I hear from time to time there are lawyers that don't go to the pre-sentencing interview. I think that's grounds for disbarment. I mean, that's malpractice.
I agree.
I can't even fathom it. If the clients run out of money, you knew when you took on this matter what you're obligated to do. You got to go to the pre-sentencing interview. There's no two ways about it. You got to reach out to probation. You got to ask them. I ask this question all the time. Is there anything I can provide you before the interview? And most of them say, well, that's the government's responsibility. And I say, I understand that, but is there anything I can help you with? Is there anything we can provide? I meet with my clients prior to the pre-sentencing interview to get them prepared. And sentencing, which we've been preparing for from day one, is such an all-consuming process. And look, you mentioned all the 10 or 100 things, right, that are going on, with thousands of things. It's overwhelming for the individual involved in it. And we try to, provide guidance and say, let us and our team take on some of this burden. You have to be responsible. You have to, be committed to it, but let us take this stuff on. We've been there before. But it's just, I could go on for hours. The answer is you start preparing the moment you get assigned, and you can never start too early. You can only start too late.
I'm so grateful that you have spent so much time with us. I look forward to doing many of these interviews. Everyone, besides posting this on YouTube, I'll post it on the White Collar Advice podcast. I'll post it under Andrew's biography on our top WCA website. I'll also post it as a blog, and I'm going to share it with our list, because you need to understand the importance of a proffer or probation report of mitigation, because even if you've already hired a lawyer in a different part of the country, this video will help you create questions and hold your existing lawyer accountable. So Andrew, thank you. We're so grateful that you're in our community, and I look forward to doing many more of these interviews in the weeks, months, and years to come.
My pleasure. Thanks for having me.